Kelvin, can you hear us? If Kelvin is not there, I can request Hannah. You can pray as we begin.
Yes. Good afternoon, everyone.
Good afternoon.
Let's bow down our heads and say a prayer. Heavenly Father, we come before you this afternoon. We thank you for your gift of life. Thank you for your gifts. Thank you for this meeting. Thank you even for giving us the opportunity to be in this course. As we partake of it, Lord, may you bless us. May you give us wisdom. May you give us knowledge. May you give us the ability to understand and interpret everything that we are going to learn for the benefit of our organizations and even our personal lives. This I pray shortly, believing and trusting to your Son, Jesus Christ. Amen.
Amen. Amen. So thank you so much, and welcome to this first learning webinar. We had a webinar on Friday, which was mostly orientation and us getting to know each other. Today we'll get a bit deeper into the content and to understand Unit 1 and 2. Before I hand over to Rose, Deputy Data Commissioner, who is with us, I want just to give a few of us to just share their brief experiences on how it has been in the last few days of the safari. Any volunteer who wants to share something, share your experience and how you are cracking it out. Any volunteer, you can raise your hand. Any volunteer before I point a few people? Okay. I can give to Elizabeth. Elizabeth, you can share your experience, how you are faring, how the safari is, how you are cracking it out. You can share with us. Elizabeth, I'm left. Okay. Okay, Paris, you can share with us.
So far, my experience has been really good. I'd say that the course is quite interactive. That is one of the things. At first, I didn't think it was that interactive, but what I love most about it is that in every stage, in every topic, you're able to give back your feedback, you're able to address something, and then at the end of it all, there is a segment where you're able to post your question. So far so good. The other thing I've noted is that you have to really put in the work. You have to put in the work. You really have to put in the work if you want to grab the concept of this. So yeah, that is all.
Thank you so much. And Paris, let me request another person. You can put down your hand. Let me request Bob. Bob, you can share your experience the last few days with us. Bob Idaka.
Thank you very much, Mr. Karanja, and good afternoon to my classmates. It's been a very good and smooth experience, in spite of the fact that the first few days were quite challenging, trying to maneuver through the system and trying to understand how the system works, how I score, and all that. But generally, it's been quite an informative journey. I'm still struggling with the 30%, but I'm doing quite well in terms of application of the content. Like I mentioned during the introduction phase, we have a humongous database of members, and we need to be very keen on how we manage and maintain this register while still adhering to the lessons that we're learning in this session. So I really appreciate and I'm grateful and looking forward to completing the journey.
Wow, thank you so much. Let me give the last person. Let me give Mikhail. Share your experience and how the safari is.
Thank you very much, Mr. Karanja. So my experience has been good. The course is really informative. The breakdown of the units and the way it builds up from the introduction and then going to the framework, and then now our rights as data protection, data subjects, and also aligned to the aspects of principles of data processing. So I would say the course layout is good. The mode of delivery is also good, because then there's the document, the PDF that has all the notes you can read, and also there is now the interactive videos from the facilitators. That is very good. Now that this is a safari also, I may say that I have an issue with those people who wait, we are asleep, and they start the journey. When we wake up, they are at 28. They should wait for us. We go together. But anyway, it is good just to encourage everyone. We need to keep on pushing. It is very, in fact, the part that I really enjoyed was how we are comparing the data laws and regulations in other countries. That was very interesting. There was a lot of insight there. There was a lot of appreciation of Mauritius, and I think it's Ghana. Yeah. Is it Ghana? Or yeah, I think Ghana is quite ahead at this. I was shocked. I didn't know that compared to Kenya. I thought Kenya, we are the big boys in the club. Yeah. But then that was very interesting, and also the relation between the Ministry of ICT and also the Data Protection Office. I'd be curious to also know what Ministry of Interior has to do, NC4, National Cybersecurity Command Control Center, and all those other aspects of now security aspects, because it seems to be running in a parallel line with the NC4 and Interior doing things around cybersecurity and counterterrorism. At the same time, Ministry of ICT doing the same things. But otherwise, that is my observation, and wishing everyone else the experience that I'm having. Thank you.
Thank you so much, and even for elaborating the content. Now you understand why I was asking us to at least meet the milestones before you come to the webinar, because by the time you come, you have already gone through the content. And this afternoon, we are going to have a discussion around that. I want to encourage us. The chat facility is open. Post any question. Post question. You can also raise your hand if you have something, even as the facilitator take through. I want to encourage us to engage, because we are very privileged to have Rose Musero, who is the Deputy Data Commissioner at the Office of the Data Protection Commissioner. This is the very right person to have in this session. And the most important thing is that Rose has been involved in this program from the onset and has facilitated this program and has given so much value to this program. And therefore, you have the right person in class today. You also have the right person in the Office of the Data Protection Commissioner who with us. And therefore, I would ask us to ask questions, to engage, and to ensure that by the time we take through this session, we have really gotten all those aspects of legal and regulation and institutions and organizations and all that, and even understanding data protection. So I want to, at this time, welcome Rose to take over the session. Over to you, Rose.
Thank you so much for that, Nathan. My apologies. I think my camera is a bit off. I'm not in town at the moment, and so please bear with me. I put my camera on for just a brief moment just to say hello, and then I'll turn it off just so that I can have, if I see it's interfering with the connectivity. So today I'm here to take you through units 1 and 2, and I'm glad to see that there is a lot of feedback that has been given, a lot of discussions that are being had as well, even as we go through the learning. So I'll pick up on some of the discussions that have been had, just to put some input and to give some perspective on a data protection aspect to some of these discussions. But we'll start with unit 1. Just to briefly go through, and I'll try not to repeat what has been said. But for those of you who've gone through the unit, you will know that the basis of this unit is a discussion of the Data Protection Act in Kenya specifically. We look at the key concepts, principles, and then we look at how data protection plays out, not just in a global sphere, but also just locally, and that comes in unit 2. So the Data Protection Act came about in November of 2019. It was sworn into, or it was sworn by the, or signed, I should say, not sworn, signed by the then president on the 8th of November. And for all of you who are in, or some of you who are in the legal field, you will know that usually laws take 14 days after being signed to come into effect, unless they stipulate that they come earlier. So in this case, it commenced on the 25th of November 2019. To give effect to Articles 31C and D of the Constitution, but also Article 35(2) of the Constitution of Kenya. The Constitution effectively says in Article 31C and D that a person has the right not to have information about their private affairs or affairs relating to their family unnecessarily required. And D, a person has a right not to have any of their communications infringed upon, their private communications. And then 35(2) looks at the right of a person to have any information about them that is false and misleading, rectified, or deleted. So this is a basis of data protection. It's actually based on the basic rights of the human rights that are attached to citizens and persons in Kenya. And the Data Protection Act established, or gives I'll say it is an overarching legislation on data protection in Kenya. Previously, there were a number of legislative frameworks that dealt with data protection. So for example, if you go to the KICA, this is a Kenya Information Communication Act, you'll find that there's data protection provisions, specifically where it comes to mobile network operators, as well as consumer rights. If you go to the Consumer Protection Act, that is governed by the Communications Authority, you'll find aspects of data protection. If you go to the CBK regulations, you'll find aspects of data protection for the areas that look at the financial sector. And so there was a segregation, or could I say there was a number of provisions within various acts, but there was no one unifying law when it comes to data protection. And so the Data Protection Act came to do this, or to fill in this gap. It also established the Office of the Data Protection Commissioner, who was appointed on the 16th of November 2020. And the Data Commissioner is Madam Immaculate Kasait. And the office is called the Office of the Data Protection Commissioner, even though the name of the office holder is Data Commissioner. Just for your information, the office doesn't have a board, and so it has a very similar structure to the Office of the Auditor General, for those of you who understand how that works. There's a head, and then there are people that are staff that are under the Data Commissioner, or if you have it, the Auditor General, but there's no oversighting board, like in many other government organizations. So the Data Protection Act came into effect for a number of reasons, and I'll speak about these broadly. I know that I meant to talk about Unit 1 and 2 separately, but allow me to just mix them up just a little bit. I think for understanding, it'd be good for you to appreciate the journey of my sincere apologies. I think I'll turn off my camera. As I mentioned, I'm not in town, and so my connectivity is a bit sketchy, but we will continue. So the Data Protection Act came into effect for two main reasons. The first one was to give effect, obviously, to the Constitution and the human right to privacy. The second one was largely because we looked at the aspects of the digital economy, and this is how do people interact in a space where they're digitally enabled, they're using gadgets, or using broadband or mobile devices to actually interact, to trade, to connect, to communicate, and things like this. Service delivery even for government. And one of the things that we saw is that data increasingly is becoming the biggest, I guess, asset in the digital economy. So I think from one of the exercises you would have seen, or conversation that was had in Unit 2, you'll note that a lot of the big companies, especially the tech companies, don't actually sell you anything as an individual, but they harness a lot of your data specifically to sell to other entities for marketing purposes, for research purposes, to enhance products and things like this. And now with the advent of AI, a lot of them are actually using your information to determine your patterns, so that they can then effectively increase the productivity of their products, and then sell them back to you, or sell this information to somebody else for the purposes of then adding on to the data sets that they have. So with this, we found that it was very important to have an Office of the Data Protection Commissioner to then govern how people are actually using information. So information is no longer being used in a manner where the person who collects determines that necessarily advising or seeking consent, or even being accountable to the individual who's being affected. Now the tables have turned, so the ownership of information or data specific to an individual is owned by the individual. So this is their information such as their name, their address, their phone number, their email address, and then there's sensitive aspects of data such as your health status, your biometric information, information about your spouse, information about your children, and all of these things that need an additional layer of protection. So in this space that we live in, where technology is advancing at a really high rate, the majority of the things that we do, the interactions that we have, are data fueled. So we live in we can call it a data economy. And so the Data Protection Act is extremely important to ensure and to govern the fair and legal and proper usage of information about individuals, either both by public and private sector players, to ensure that people are held accountable in the event that information is actually taken in a manner or used in a manner that is inconsistent with the reason, the purpose that it was collected, and the like. When we talk about data, and I know that this is something that's a debate that we have quite often as to what's the difference between data and information and data, and things like this. So one of the things that I think for any of the IT people in this space, you must distance yourself just a little bit from the usual definition of data and information, because in the Data Protection Act, you will see that data is actually defined as information that is processed either electronically or manually, recorded with the intention that it should be processed, or forms part of a filing system, or information that is held by a public entity. So personal data in this case is defined as information or data, as has been defined in the Act, of an identified or identifiable person. So for example, if you've got my phone number and you can easily link that phone number to me, that technically will be my personal information because it is information relating to an identifiable person, right? Data protection does not cover issues of commercial entities or non-natural persons. So these are legal entities. So for example, companies, public authorities, even if, now with androids or robots and things like this, those people do not have or do not cannot feel, don't have a human right. There is no human right that attaches to them, and so they are not deemed to be natural persons. So the scope of the Data Protection Act specifically in Kenya looks at any natural person that is located in Kenya, which means that even though an entity is not located within the Kenyan borders, as long as they're collecting information about people who live or who are resident or who are present in Kenya at the time of collection and processing, then they are bound by the Data Protection Act. So an example would be, all of you use Instagram, I'm sure, or Facebook, or even WhatsApp. You know that Meta, which is a company that owns these three entities, doesn't actually have a presence or is not registered in Kenya, but it collects information about people in Kenya. And so they are bound by the provisions of the Data Protection Act. When we talk about processing as well, one of the things that we need to appreciate and understand is that it does not take on the colloquial meaning that we attach to processing. So I know that in the usual or natural form of translating or defining processing, we would usually look at, we would say that processing is a, using or turning information into something else, as an example. In this case, it isn't. That's not the definition. So processing is a catch-all term of anything, any way that a person or an entity can handle information or handle personal data that's deemed to be processing. So it encapsulates collection, deletion, sharing, usage, the like. So it's important. Deletion, it's important for us to note that as well. When it comes to data protection, there is an increasing recognition of the fact that data protection is a right that attaches to individuals, more so in recent years. And this is because of the advent of the General Data Protection Regulations. This is the EU Data Protection Regulations. They are broad. They're almost like a convention. If you think about how the EU works, it's slightly different to how we work. So it's a convention that then binds the players or the member states of the EU, who then have to develop their own data protection laws that align to the General Data Protection Act, regulations. So for example, if I take a country like Germany, they have the German data protection laws, but they have different, I think they've got about 16 regions or 8 regions or something like this. Each of those regions has a data protection authority. So they don't have a structure such as ours, for example, that has just one data protection authority that looks at the entire aspect of data protection. They have multiple for each region. So say, for example, in Kenya, it would be that every county has their own data protection authority that governs the processing of personal data within that particular county. And then they have a federal, which would be a national level data protection authority that looks at the interpretation of the different data protection authorities within the regions. So it takes a different form. However, the data protection general regulations were actually seen, or they're held to be the golden standard or the best practice for data protection, but they're extremely stringent. And so what they did is that they forced a lot of players, a lot of countries that process personal data of EU residents to get to a point where either they were amending their laws, or they had to show a very strict compliance or seek something called an adequacy decision, which is a decision where the EU data protection board makes a determination that laws are essentially equivalent, so that there is an ease of transfer from one country to another outside the EU, or from the EU to another country. This has forced us to look at data protection in a very broad way, because there's this restrictions. And so for African countries, we've gotten to a point where if we did not have a data protection act, then it's very difficult for us to even trade with countries within the EU, especially where information is meant to transfer between one country to another, noting that obviously we live in a digital world. And so the borders are less structured as in the physical world. And so given this movement of information, there has been an increase. So you'll see, for example, in Africa, there are 33, if I think 36 member countries within the AU that have a Data Protection Act. There are others that still don't have a Data Protection Act. Within East Africa, there are quite a number. I think most Eastern African countries have actually developed a Data Protection Act. Some of them are still in the process of operationalizing. So, for example, Rwanda, I think, is having their Data Protection Act to come into place. Sorry, to come into effect. They have an act, but it's coming into effect, I think, on the 23rd of October. And so there is a trend of this. But there's also this aspect of monetization of personal data. As I've mentioned, a lot of the big companies globally are tech companies that don't actually sell to individuals. And so there was a need for us to protect individuals, especially individuals' right to privacy, so that we can see that entities are actually keeping in line with the laws and are kept accountable or held accountable when they use information in a manner that is not consistent. There are a number of concepts in the Data Protection Act. I would assume that we've all gone through these sorts of the slides. So I'll just quickly go through what I felt perhaps was unclear based on the answers that you were giving, specifically when it comes to data controller and data processor relationship. So if we could have whomever's mic. Thank you. So when it comes to data subjects, data processors, data controllers, there is especially data processors and data controllers, there is seeming to be a misunderstanding of what that means, especially for your entities. So I'll give an example. I think someone mentioned that in terms of the data controller, they were a data controller or data processor because they transferred information to, or they process certain information for KRA, NHIF, NSSF, and things like that.
Have we lost Ross?
I'm terribly sorry. No, I'm here.
It's okay.
Is that there must be a. Can you hear me?
Yes, you are
Hello?
on and off at
Oh.
some point. You are on and off at some point,
Sorry.
but now we can hear you.
Wonderful. Sorry, my internet again intermittent. So I'll try my best. In terms of a data controller again, it's a person who determines the purpose of collection. So in terms of an employee-employer relationship, as if I had a company and I employed certain people to work for me, there is a law that governs how I will collect, but I determine the purpose of collection. I see comments about my camera. Again, as I've mentioned, it's really difficult. I'll keep it on, but there will be a point where I might need to switch it off. But we'll see how we go based on the connectivity. So a data controller, that as a data controller, I would be able to collect information from my employees. I'll be able to determine based on the provisions of the Data Protection Act, from the Employment Act, what information I need to collect. I also need to look at the KRA. So this will be the tax procedures as well as the Income Tax Act to look at what I need to collect. I would look at the NHIF Act to see what I need to collect. If there are employees that have HELB debts, I then look at the HELB Act to see what I need to collect. Simply because I remit this information to HELB, NSSF, KRA, and the like does not make me a data processor. I would be a data processor, however, if I was providing a service to HELB, NSSF, NHIF. If there was a contractual relationship between me and NHIF or NSSF or KRA that required me to process information for them. And so they have outsourced a service that they would have otherwise done to me, then I would be a data processor. But please note that simply because you're remitting information to them does not make you a data processor. They are a data controller in their own right, similar to you being a data controller in your own right. So that is key to understand. One of the other things that you need to understand is a data subject can also be a data controller or a data processor. Now, the definition of a data controller and data processor looks at a natural person, an organization, a public authority, and the like. So simply because a person is collecting information from you doesn't necessarily mean that they cannot, if they're not a company, they cannot be a data controller. So it's important, or data processor, it's important to identify that aspect as well. Another interesting aspect of the Data Protection Act is that it classifies certain information. So it classifies personal data, which is broadly defined as information that relates to an identifiable person. It doesn't delineate or does not specify what this information is, but we know what it is. It's a name, as I've said, a phone number, a telephone number, an address, an email address, a photograph, because that can be used to identify me, and any other subsets of information that will actually be linked to me. But there is another category of personal data that is deemed to be extremely sensitive and requires additional protection, but also has restrictions with how someone can process, or around how someone can process. So this is sensitive personal data. So health status, ethnic or social origin, race, family details, and things like this. You will note that a lot of the laws that talk about data protection, if you look at the Ghanaian one, if you look at the EU general data protection regulations, even the Mauritius one, you will see that there's differences in how they've defined sensitive personal data. I think the EU calls it special categories of personal data. You will see that they're different. So for example, in Kenya, we found that personal data that relates to your political affiliation is something that is shared quite widely. So if I'm a member of a political party, I will share it with people. I'll usually discuss my political opinion, and so we did not find it necessary to actually have that as a sensitive personal data. Also, there's aspects about trade unionship or trade union membership. We do not have that in our data protection laws, simply because we have it's not something that we deem as culturally to be sensitive personal data. And so is not afforded that additional amount of information. However, you will see in our laws, we say spouse or spouses. Spouses is something that is normal culturally for us. And so we have incorporated that into a Data Protection Act. A Data Protection Act borrows largely from the GDPR, the General Data Protection Regulations, but we have customized it in a manner that looks at the nuances that exist in the Kenyan landscape. And that has, so you will see certain differences. You'll come to talk about aspects of the lawful basis, I think in Unit 3 or 4. But one of the things that I do want to emphasize, even as you go through the learnings that you're going through, is that consent is given primacy in Data Protection Act simply because there is an intentional effort to move or to shift ownership or responsibilities in terms of how information is being dealt with from the entity that is processing the data or utilizing the data to the individual. So the individual now has ownership. They can request, they have rights, they can request certain information about them. They can dictate how certain information can be used. They can determine whether information will be transferred out of the country or not, if it's sensitive personal data and the like. And you'll see this as we move forward. However, please note, even as you continue to process data protection, that consent is not the only aspect of collection of information. There are many other aspects of collection. So for example, there is performance of a contract. Some of you are employed, and so your employer needs to collect certain information about you so that they can fulfill their obligations, such as paying you, paying KRA or remitting your payee to KRA, remitting things to NHIF or NSSF and things like this. They have a legal obligation, or by virtue of a contractual obligation that they have with you, they need to do these things. So it does not mean that your employer has to ask for your consent in order to do or to collect certain information or remit it to KRA. However, consent is the only one of the lawful basis that has particular income. So for example, you see data that it needs to be informed. Informed means that there needs to be clarity in the language that is used. So if I speak English and someone seeks consent from me in French and I do not speak French, then that can't be informed because I do not know what is being asked of me. It has to be voluntary, which means that there cannot be any conditions that attach to it. So for example, if you're using, and I'll give the example of WhatsApp again. If you're using a platform, if you're using an app, if I'm using WhatsApp, I'm required to give certain information. If I do not give certain information, I cannot use WhatsApp, right? And so it is not voluntary. It is almost like a contractual obligation that I have. There's terms and conditions that they give. And so even when they ask for consent, that consent would not be valid. So it has to be free of any conditions. So in a consent situation, I'd still be able to use WhatsApp even if I didn't give them my personal data. A data subject needs to have the capacity to understand and communicate their consent, which means that a person under the age of 18 does not have the capacity. Anyone with a mental incapacity cannot give consent. And so they cannot understand it, they cannot communicate their consent. It would not be legal or valid. Consent has to be expressed, which means that I have to make an affirmative statement or do something in the affirmative rather than being passive. So simply because I do not say anything, it cannot be taken as being consent. It has to be specific, so consent can't be ambiguous, which means that requesting for consent can't be. So if someone says, I need to collection, it's to be an aspect of specificity. They need to say, I'm collecting information for the purposes of keeping a register of people who have visited a particular premise. Could you please give me your consent? And then I say yes. And if I say no, there is no consequence that attaches to it. So those are some of the conditions. It also means that I can withdraw my consent because of it's not conditional on anything. And that's one of the aspects. Data localization is also an interesting one. I think you'll be speaking about this in, if I'm not wrong, in Unit 6. If you haven't already looked through that, it's quite interesting. Data localization is a statutory or regulatory provision that states that information, specified information, must be kept within a particular country. So in Kenya, we do have data protection or data localization provisions, which is based on the legal obligation in the general data protection regulations. However, it is not for everyone. So there are certain aspects of individuals that can transfer information out of the country freely. Then there is the ones that are subject to data localization provisions that must keep information in Kenya, and this is they must keep a specific set of data or the personal data. They must keep one serving set at any time. So, for example, if I give you the 2017 IEBC situation where they tried to call on the information. If it was done in this present day, then IBC would be found to be in breach of the Data Protection Act because they had no serving copy here. They would have said they have a copy here and the servers are located here and they have a backup in France, for example, and that would have been in line with the Data Protection Act. We have a lot of aspects, like I've mentioned, that talk about data protection, a lot of frameworks, regulatory frameworks that exist when it comes to data protection. We don't operate in a silo. And so a lot of data protection initiatives and data protection laws have actually come about by virtue of existing legislation that have been there for quite a number of times. So if you look at the data protection principles, and I think they've aspects that have been touched on. But if you look at the data protection principles, you will see that they form their base on OECD. This is the Organization of Economic Cooperation and Development. Unfortunately, Kenya is to 1980 that set out principles of data protection. Again, they set out the principles of data protection, which are the principles that are widely adopted even now in the GDPR, in the Data Protection Act, and in many data protection legislative frameworks. Another thing that you will see is that when the OECD developed their documents in the 1980s, which is quite a long time ago, almost 43 years now, there was also a European equivalent or and when I say European, I mean the continent of Europe, which then the countries within the continent of Europe form a coalition called the Council of Europe, which is different to the European Union. So the Council of Europe also developed a document called it's called Convention 108. It is, or Convention 108 plus, it was changed in 2018 after the GDPR came into place. But Convention 108, the full name is a Convention on the Protection of Individuals with regards to automatic processing of personal data. And they set out a number of principles that are very similar to the OECD principles, but specifically of importance. This document was the first ever document or the first ever legally binding international instrument in data protection. However, to place, again, like I said, privacy is new or data protection is new in Kenya, but has existed in a number of countries for years and years. So for example, in Germany, I think they got their first data protection laws in the 1960s, following the World War, simply because of the nuances that came around with the Holocaust. And so there was a need for them to do that. In Africa, I think we had I want to say I think Ghana was probably one of the first, either Ghana or Mauritius was one protection law. So Ghana has had a data protection act since I think 2012. We, unfortunately, as Kenya went through a process, I think we've had our first draft bill in 2012. And then every 2 years thereafter, until the data protection came into place, we had a bill. That was either rejected for failure to meet statutory requirements or whatever it was, but they never seemed to quite get any footing. Another instrument bringing closer to the continent is a convention on cybersecurity and data protection, which is also called the Malabo Convention of 2014. The Malabo Convention, even though it was signed in 2014, as at June, it had its 15 signatories, which means that it is now the second international document on data protection, or the second international treaty on cybersecurity and personal data protection. So this is huge for Africa, obviously. However, 16 out of 55 member states is still not enough. And so there is a need for more entities and more countries to actually ratify the convention. Kenya is making moves, and there was a presidential directive in January of this year for us to ratify the Malabo Convention, which is in the works. The reason why there is a push to do this is because there's something known as the AfCFTA, or the African Continental Free Trade Agreement, which looks at digital trade specifically. And one of the requirements in that is to look at data protection and what data protection, or how data protection would look in digital trade. So there is a push to have a harmonization of laws, specifically when it comes to data protection in that. And so if we don't have similarities within our laws, and it is very difficult for us to have cross-border data transfer, so personal data moving from one country to another, and have enforcement mechanisms that are conducive or meet the requirements of, say, the Kenyan laws. So if I transfer to Tanzania, and Tanzania has aspects of their laws that don't offer the same protections as those in Kenya, then it will be almost impossible for an individual whose information is in Tanzania but is in Kenya to actually ask the Data Protection Authority in Tanzania to enforce that. And it will be very difficult for the Office of the Data Protection Commissioner to also engage with that organization, with the Data Protection Authority in Tanzania, to ensure that this is being done in a manner that is conducive. As I've mentioned, again, we have a number of laws, and I like the question that was asked by the gentleman that spoke about how exactly do we deal, or how do we incorporate or engage with a Ministry of Interior, NC4, NC3 technically no longer exists. I think he mentioned the National Cyber Command. It exists as a secretariat to NC4. And so we'll speak about this. So when we talk about data protection, it does not exist in a silo. So this means that the Data Protection Act is governed a lot, or takes or borrows a lot from other legislative provisions. What this means is that if there is, for example, an issue relating to information about a child, the Data Protection Act specifically says that a child cannot give consent, but then their legal guardian can. For us to determine who a legal guardian is, would need to go to the Child's Act to find out what that means. Similarly, if there is a collection of information by your employer, again, if you think, or if a complaint is made that information or too much information has been collected, what we would usually do is we would find out what the Employment Act says and what it specifies when it comes to collection of information. And that would be the basis for us determining whether the information is in fact too much, right? So we're exist in a space where the Data Protection Act it provides risk frameworks. It's a risk-based legislation, but it does not specify or restrict or give, so for example, if you look at the retention provisions, there's no specificity with how long you should keep information for. However, we know that information should not be kept in perpetuity. So where do we go to find out what is too much and what is too little? Usually there are statutory provisions that govern this. So for example, if it's performance of a contract, the Statute Limitations Act, or the, I think it's the Interpretations Act, will specify that there is 6 years within which a person can bring a claim for performance of a contract. Thereafter, they are statute barred or unable to bring a claim against an individual. And so we will make a determination that 6 years is sufficient, and then thereafter they will need to delete. The CBK Act specifies that for and the anti-money laundering laws, the POCAMDA laws, the proceeds of crime and anti-money laundering, specify that financial institutions should keep information for a period of 10 years. So we would say, okay, fine, based on the retention period and based on the act, you are required to give or to deal with information in this particular way and retain it for 10 years. So it doesn't prescribe, but we do get a lot of information from other laws to determine how exactly processing is being done in a fair and proper manner. So when it comes to certain laws, such as access to information, computer misuse, and cybercrimes, there's also a need for us to balance the two. So access to information is also a human right that is stipulated in the Bill of Rights in Article 35 of the Constitution. However, access to information does not necessarily mean that you are entitled to receiving information or personal information about another individual. It means that you are entitled to receive general information about an institution. Remember, an institution is not a personal data subject, but also says that you need to collect certain, if you want to collect certain information, then you are bound by the Data Protection Act, and you would need to have permission from the person who's, so if you want my information and how I'm employed with ODPC, then you would need to then seek my consent for you to collect that information, unless of course it's a matter of public interest, in which case you'd need to prove or to get a court order to collect that information. Same with the Computer Misuse and Cybercrimes Act. And this is now to answer specifically the questions. How do we interact? Cybersecurity and data protection are very closely related. In data protection, there's aspects that we look at that have a cybersecurity aspect. And so in most cases, you'll find that data breaches usually affect an individual or data subject or deal with the collection of information relating to an individual. And so there will be aspects of data protection within a cyber breach. However, not all cybersecurity incidents are related to data protection, similar to how not all data protection breaches are related to cybersecurity. So, for example, I saw an example of someone who'd said that an individual, I think they signed on to a company, and their credit card information was stolen, I think, and they found a lot of transactions out of that. So in that case, it deals with both. It touches on cybersecurity because obviously there's a cybersecurity issue, which would mean that the organization or the entity, the online shop, didn't put enough safeguards to protect the individual from somebody else actually taking their information. However, there's some instances where it is not a fault of the online store. It is a malicious attack, such as you look at recently, we've had DDoS attacks, this distributed denial of service attacks with eCitizen. No actual information was exfiltrated, which means no personal data was taken out of the system. And so for us, because no personal data was involved, it was not an ODPC issue, but it was an NC4. This is a national coordination committee on computer and the National Computer Crimes and Cybersecurity Coordination Committee that is headed by a director that I think is part of NC3, the National Cyber Command Center. So in that instance, we would look at the data breach notification, and then we would engage with NC4 to determine whether they can then investigate from that aspect. NC4 noting has lots of members in it. So it has CBK, it has DCI, it has CA, it has I think it has the Defense Forces. So there's a number of actors. And so that's how we interact on that basis. And so coming back to the answer to that, there is no specific aspect of or provision that talks about how we should interact with the Ministry of Interior, but by virtue of there being a close relation, at this point, we engage especially where there are cybersecurity incidents that touch on data protection, we engage in that way. Within our act as well, the Data Protection Act, there's provision for us to engage with the intelligence services or any police service with issues that touch on national security or offenses, because obviously we don't have the powers within our institution to actually prosecute certain offenses, but the National Police Service would have those powers to do so. So that's the aspects of collaboration. I will stop there and start to answer the questions that have been put in place. And I think with that, we'll get into some of the considerations as well. So we have certain questions, and my apologies when it comes to there are some questions that have been put in with respect to WorldCoin. This is currently still under investigation. I will not be speaking about this, but there is a lot of information in the public domain about what the ODPC has done with respect to WorldCoin. And so if you can, there's parliamentary proceedings and things like this. So I would recommend that you have a look at it in that respect as well. But also you'll see that WorldCoin doesn't operate in Kenya anymore because there is a restriction on that. And so that's part of the measures that the government has taken. So I'll just for those questions on WorldCoin, I'll leave them there. There is a question from John Kanye that says there are people who operate parody accounts on social media, especially with names of public figures. Sometimes they post controversial information and attract attention to these pages. How are such acts treated under the Data Protection Act? So the Data Protection Act is a civil act, so it doesn't attach criminal responsibility. However, such functions would be dealt with under the Computer Misuse and Cybercrimes Act, because the Computer Misuse and Cybercrimes Act talks about impersonation, fraud, cyber harassment, which this would be, and puts a criminality to such things. So we wouldn't, under the Data Protection Act, be able to investigate the criminality of these things. And so what we would do is that we would inform, if such a complaint is made under us, we would inform the NC4 that this is something that is happening, and ask that the individual reports to that entity. There is question on data on smartwatches. Does the Data Protection Act and the regulations encompass the protection for use, sharing, and of wearables? Absolutely. Like I mentioned before, the Act has extraterritorial powers. So if there is anyone who's using a for example, I use a Garmin. If I find out that Garmin is selling my information and I wish to report it to the ODPC, I can do so, and Garmin would have to show that they are compliant to the Kenya Data Protection Act. But they should be compliant to the Data Protection Act anyway, because again, as I've said, the Data Protection Act application is or applies to entities, whether they're resident or not resident in Kenya, that process personal data of persons located in Kenya. Are there penalties? Are the penalties stipulated under the Act sufficient to curb personal data misuse? I'm not wearing this as I'll answer this as a both a Kenyan and a person who sometimes gets frustrated with the penalties that are put into place, and I'll give I guess a background as well. When we drafted the data protection, so I was involved in the drafting of the Data Protection Act and the regulations. When we drafted the Data Protection Act, the provision was actually a penalty of 5 million Kenya shillings, or 1% of the turnover, whichever is greater. When it went to the National Assembly, the legislators thought that because we deal with a lot of entities that are deemed to be small or micro enterprises, that they needed to cap the fines to 5 million. And so the whichever is greater turned into whichever is less. So it provided a cap of 5 million, so there is no way for us to increase it. For those of you who've been following what the Data Protection Commissioner has been doing, you will see that there have been provisions made or recommendations that have been made by the Data Commissioner to increase that cap so that the penalties that are applied are actually punitive, so that people can actually take the Data Protection Act seriously. At this point in time, that hasn't been done. So are they sufficient? I do not think so. And I'm looking forward to a time when they're increased slightly so that they can have the intended effect. Regarding data processing, and this is from Elizabeth Itotia, that says sometimes some of these loan companies give loans to persons getting the loan and add another person as a guarantor without knowledge and or consent. In the case of default, the loan company's Harris is said guarantor. how is this legal and what can be done to avoid this harassment? So one of the things that the Office of the Data Protection Commissioner has done is that we have developed data protection guidance notes that stipulate how digital lending or digital credit providers should treat guarantor situations, as well as look at harassment of individuals. It's not legal for two reasons, actually. The first one is that a person who does not know that they've been listed as a guarantor cannot guarantee a loan. That's simple law of contract. Secondly, if you do not give your consent or you do not accept to be part of a contract, you cannot be bound by it. And so the processing of your information on the basis of consent or a contractual provision would be unlawful under the Data Protection Act. So we have been engaging and we've done a number of audits on digital credit providers to ensure that we're curbing this. And so that is being done. And so whenever we have a digital credit provider that has run rogue, we will penalize. We also give aspects of data protection act specify that individuals can report such instances to the Office of Data Protection Commissioner, and then it is investigated. Usually the entity will be asked to answer. There's also compensation provisions for individuals who are harassed in a way and sustain some sort of loss, whether it's mental anguish, emotional anguish, or whatever you have. And so this is being dealt with. Another thing that the government has actually done is that now these digital credit providers are licensed by the Central Bank of Kenya. And so if they don't adhere to the practices that have been laid out by the central bank, then they would be unlicensed and they wouldn't be able to provide loans. And so there is an additional legislative provisions that deal with that. Regarding informed consent, if a patient walked into a hospital and refused to provide personal information, what would it be legal if the hospital denied such a person treatment? This is an interesting question, but it would not be illegal for the person to provide care or the hospital to deny care. The reason for this is that I would require to know you to enter into a contract with you where I provide my services. And so it is not on the basis of consent that you receive medical treatment. It is on the basis that there is a service that is being provided and a payment that will be done. Whether you are the one who is paying or NHIF is paying on your behalf or whichever is your insurer, there is the requirement that service is provided for a fee. So even a hospital visit it's not for free. Someone has to be reimbursed somewhere. And so if you do not provide information, if a patient denied to provide information, then the doctor would not have sufficient information to treat the patient, unless, of course, it's an emergency situation. And so the hospital can deny services to the individual and it would not be against the Data Protection Act. Now, it could be against the Health Act, but I don't think there's a provision within the Health Act that says that they have to seek consent. Unless, of course, it's for a medical procedure, in which case it will give you options. They will tell you what exactly will happen, and then you make a decision for a particular medical procedure. But for them to do tests and things like this to determine what's wrong with you, you would need to give information to them, whether you wanted to or not. If they need to do tests, they'll take your DNA. DNA is also personal data, sensitive personal data. And so you would have to give this information and it wouldn't be on the basis of consent. What are the bare minimum personal information one can give, for example, when they check into a hotel or when accessing a building for registration? So this is defined in the Private Security Regulations Act of 2016. That's a Private Security Regulations Act 2016 under Section 48, which says that a person must either provide a ID and deposit the ID with the person when they're entering a building. This is the private security agent, or in the alternative, provide their name and the ID number to this individual. So that's the bare minimum. It is a statutory provision. So if you look at that, then you can then decide if they're requesting for more information, you can choose to decline, and you can quote the Personal Security Regulation Act of 2016. Is there a balance of probabilities when it comes to giving of data accessing any building at a security? I'm not sure what this means in terms of balance of probabilities. Yeah, I don't know what that means, but I'll say that there is a statutory requirement that anyone who's entering a building would need to identify themselves to the private security agent by either giving their ID to the private security agent for the duration that they're in the building, or in the alternative, providing their name and their identification number to the entity. This is for security purposes. And the act actually came into effect after the Westgate terrorist attack, and was for the purposes of identifying the individuals who entered. And so when you do not know the people who've entered into a building, it's very difficult for even national intelligence service agents to figure out who exactly is responsible, but also the people who are affected. How can you sorry for that. The question about participants. So I think we all have to collect this information. I know that as government agencies, we collect certain information for the purposes of accountability. So we need to account either to the Auditor General or our internal auditors as to what we've actually provided. And so you would collect the bare minimum information, and you would also advise participants that you're collecting this information for, and advise why you're collecting and what you'll be doing and what you'll be doing with the information, and how long you'll be retaining it. So, for example, in ODPC forms, we have a privacy policy or a privacy statement at the top of the form, and then we only collect the name, the email address, and the signature of the person. We don't collect a phone number because that can be extremely sensitive. And so we collect the bare minimum information. Sometimes we don't even ask for the email address, especially if we know that we have it. And so there are certain measures that you can put into place where you're collecting, and this is through aspects of data minimization. So collecting only the information that is necessary for you to actually achieve the purpose of knowing the participants. Where a person is reluctant to share their information, again, as I've said, you need to identify the individual to know that they have been trained. So at the bare minimum, they need to provide their name, and perhaps even the organization that they work in. And if there's reimbursements, and they need to provide an email address or a phone number. So if they're reluctant, remember that this information is not usually collected on the basis of consent. So you can decide not to provide them without training if that is the case, because there are accountability provisions that you're also bound by. So it's important for you to ensure that you're able to meet your obligations and collect the information that is necessary to achieve that purpose. However, I think in the next few units, tomorrow and the units after, you'll be talking about the lawful basis. And this will then look into more deeply how exactly you go about in ascertaining which lawful basis to rely on, so that you can then meet that objective of identifying or advising an individual why exactly you're collecting certain things. The next question, does video footage qualify as data when it has a capacity to identify? As I mentioned, yes. Absolutely, it does. Video footage does. So they said there have been cases where ODPC conducted training in 47 counties using video recordings without obtaining consent, resulting in individuals unexpectedly appearing on television broadcast that did that, but we did advise if you have any specific complaints, you can always make a complaint to ODPC. I don't think I'm aware of this aspect, so please feel free. We've got a form on our website that you can post your concerns in, so you can state that, especially if you are aggrieved. Video footage does qualify as personal data, or your face qualifies as personal data. Again, it's usual practice for us whenever we're filling in the consent forms or we're filling in attendance sheets, there is a tick box exercise that says, do you consent to us taking photographs or things like this? Usually it's for posterity measures. But if you were aggrieved by something that ODPC has done, you can always send us a concern and we'll look into it. What is the current status and application for Rule 2.1 media houses and 2 law firms? I'm not quite sure, Jerry, what you are talking about. So you might need to be a bit more specific. Is a proposed Digital Health Bill 2023 in compliance with Data Protection Act in terms of the protection of sensitive personal data? It is in most cases. Remember, sensitive personal data relates to health data. Digital Health Bill looks at the processing of health information specifically. And I think the Health Bill also talks about, I don't know which iteration it is that you're talking about. There has been a number of changes. There was an advisory that stated that there must be a specific legal basis for collection of information for health data. And I think this is in compliance as well with the Health Act. And so based on that, so long as there's a statutory provision and the mandate is created, then it would be in compliance with Data Protection Act. Is it proper to write down your ID number? I think I dealt with that. Is ODPC in favor of the recent Digital Health Bill, which aims to establish a digital health agency? I don't speak on behalf of ODPC in this aspect, and so we need to come up with the spokesperson of ODPC hasn't come up with a direction on the Digital Health Bill. The spokesperson is the data commissioner. But that being said, the ODPC has advised on the Digital Health Bill, specifically when it comes to aspects of compliance, data minimization, retention, safeguards, confidentiality of information, and things like this. There is no redundancy between the Health Act and the bill. And if there is, we have advised on this. And so the ultimate agency or entity that looks at data protection compliance, the ODPC. However, that is not to say that an authority can also stipulate that they need to put in, or they have provisions to ensure that people within a specific sector comply with the Data Protection Act and liaise with the Office of the Data Protection Commissioner. And I think if you've looked at the Health Act as well, the Health Bill, sorry, the Digital Health Bill, you will see that there is aspects where provision has been made for an advisory to be made by the Office of the Data Protection Commissioner. I think there was even a recommendation that ODPC be on the board. As a data subject, I have a right to withdraw my consent. At the same time, the consent does not affect lawfulness of processing prior to withdrawal. I also have a right to be forgotten. How does this specific aspect apply when you consider a data controller can still lawfully process my data even I have withdrawn my consent? Well, technically, what it says is that at the time of withdrawing your consent, any processing that happens after is unlawful. Any processing that happens thereafter is unlawful. And so if you have and you can be forgotten, remember the right to be forgotten is not absolute. So if you've made an application for a right to be forgotten and there is no legal obligation for an individual or an entity to keep that information on you, then the processing that happens thereafter to your data would be unlawful after you withdraw your consent. And so the two things are not mutually exclusive. The two things are not contradictory of each other. They are actually indeed mutually exclusive. So as soon as you withdraw your consent, the legality of the processing activity that happens thereafter can be challenged. There's another question by Jerry Mina. What is the appropriate approach when dealing with an individual who hasn't granted consent to be photographed but appears in majority of the photographs alongside others who have provided consent? The appropriate measure would probably be to remove them out of the photo because they haven't consented. Remember, again, if my image is my personal data, if I do not wish to, then you cannot have me there. What I would suggest is that whenever you have conferences, for example, and there are people who have not given their consent, ensure that you point out that you're taking photos specifically of people who have consent. So if you're taking a group photo, you would ask the person who's not given the consent to step aside so that you can take a photo of the group. Or ask them again if they wish to consent. If at that time they do, then you can take a photo of them as well. So it's important for you to give that individual the right. Otherwise, you have to ensure that you do not publish any information that has someone else's photograph. Doesn't mean that you can't store it, because obviously sometimes you keep this information for posterity purposes. However, if they've not given the consent, you should not be able to publish. I think I've answered majority of the questions, but if there's any that is once anyone wants to ask or speak to their question, please feel free to put up your hand. Otherwise, I'll hand it back to Nathan to coordinate this next aspect.
Thank you. Thank you. Thank you. That was quite an engaging session. I want to take it to, I still see some questions coming. That is, should one consent photos to be in writing? And you can respond to those
Absolutely.
questions.
So, yep, sure. So consent doesn't need to be in writing. Consent can be made orally. However, the person who's relying on the consent would need to prove that they have consent. So, for example, as I've mentioned, whenever we have a training in person, we usually have a tick. So you can tick on a box when you're providing your attendance sheet to say that you consent to photos being taken. When it comes to the training lists, do not need consent. There are a number of lawful bases for collection of information. The first one is consent. But remember, as I've mentioned, consent is only one lawful basis, and it probably is the weakest one. Performance of a contract is another. You can use your legitimate interest to understand or appreciate what it means or appreciates the information that you're collecting, the people who are there, and so you can use legitimate interest. You might also have obligations that are legal obligations, or because you're a public authority, there's certain information that you need to collect. If you're doing a training, as an example, and there's performance of a contract, perhaps you're a public authority that needs to report on what you've collected, then you do not need consent to keep that attendance sheet. However, please note that you need to minimize the type of information that you have so that it doesn't exceed the information that is necessary to be obtained before you have to get consent. So as an example, if you're collecting a name of an individual and perhaps you need to contact them, so you're collecting
We seem to have lost Rose.
I'm back. My apologies. And you want their phone. So if you want to extend, say maybe you want their phone number, you want to retain their photographs, perhaps even publish it on your newsletter, then that goes beyond the reason that you're collecting. It goes beyond you keeping a file or a record of the people that you have trained, and so you will need to obtain their consent in that aspect. So for example, with KSG, for them to offer you the service, they needed to identify who you are, need to identify an email address. They need to identify which institution you've come from. And at no point, I assume, did they ask for your consent, because this is something that they're giving to you on the basis that your institution has recommended you to attend this particular training. And so on that basis, there's no requirement for consent. If they wanted you, or if they wanted to have your pictures and things like this to publish that, to say that you're the third cohort that has participated in this digital or e-learning exercise, the data protection program, then that would require your consent. The question here is, what is the status of the code? So this is actually being done. We will start firstly with a guidance note on journalism, literature, arts, scientific research, and historical purposes, which will be published this year. And then once we have determined how exactly the journalists in the media, specifically how researchers have taken on board our guidance note, which is not a statutory document, we will then use that information to prepare a practice code or code of practice for these sectors. Data protection is relatively new in Kenya, so there's a need for us to actually do a phased approach and determine how easy it is for institutions to comply before we go ahead and give a specific code of practice to these particular areas. But there will be a guidance note that will lay out practical aspects when it comes to processing of personal data for the purposes of journalism, historical purposes, and research purposes as well.
Okay, thank you. Thank you, Rose. Thank you, participants. I want to give our Deputy Director, Vera, but before I give to Vera, I want to request a comment and a vote of thanks to our facilitator, and we can get this from Faith. Faith, are you on? You can give us a vote of thanks. Sialai.
Thank you, Nathan. Sorry, I was struggling to unmute. So thank you, Madam Rose Mosero. We have learned a lot. We thank you so much for making time to train us, and I think we will be better champions of the data protection law in our institutions. And now we know where the interaction between access to information and also as regard journalism, sharing of that information. So we thank you so much. And thank you also, Mr. Nathan, for organizing this meeting. Thank you.
Okay, thank you so much. I want to give it over to Vera.
Okay, thank you very much. Thank you, Rose, for being here and for taking the session. We are very glad to have had you. I think I've sat in through quite a number of your sessions, and I've also sat in through this one. And I always end up coming out very, very, should I say, much more enlightened. And especially having you as the deputy commissioner, then it means that then we get the right-hand information very timely. And I can see when as the participants are asking questions, it's very fortunate that they can get them right from you, because then that means that is currently what is happening. We're very glad. Thank you for the presentation. I'd say, as usual, a very, very good job done. And also thank the participants for attending this session. And for the rest of the sessions that are going on, we hope to see you. At least we hope to see the participants. And of course, for Madam Rose, whenever she wants to pop in and also listen to the rest of the conversations, we'll be great. We'll be very happy to have you even as you attend. Other than that, I want to thank each one of you for the progress that you've made. I can see quite a number of you are keeping up with where we are today. And that's very encouraging, because that means that then as the presentation is made, just like you are doing today, then we can also engage the facilitator a lot more, and also from an informed point of view. So thank you very much for that. Nathan, I hand it back over to you.
Thank you so much. And we are almost coming to the end of our webinar today. And we have really had good time. Thank you, Rose, for the presentations, for responding to the questions, and thank you, participants, for asking the questions. And I'm looking forward to have a vibrant engagements in all our webinars. because if you keep quiet, if you don't engage, then sometimes it just ends there. But the fact that you have asked the questions, you have engaged, that's what has made the webinar very successful. So we are glad that we have come this far. Part of what we are to do in the remaining minutes, is to just get progress on our team assignment. One of the things is that by today, the teams needed to have at least had their names, have met, have engaged. So I want just to hear from each of the team, whether you have met, whether you have your name, whether you have the team leadership, and what are the plans of ensuring that you do your team work by the time that we have stipulated in our milestones. So team one, if I could ask team one, can you give us a brief? Have you met, and what's the progress?
Thank you, Nathan. So for team one, we've not officially met. We have the WhatsApp group. We have observed typing, and then the message is never sent. I think we are still breaking ice, but we intend to meet in the course of the week now that we also have the team assignment and discuss the same. So we'll be able to give a concrete update on our progress in the next session that we'll have.
Have you agreed on the name?
Sorry, the name for
the team name.
The team one.
Okay, is that what
or
you have
you
agreed?
needed us to have a different
yeah, you can call yourself any other. That's something you can agree on, even on WhatsApp.
All right,
agree on a name that you'll call yourself. So
All
thank
right,
you. Let's get to team two. Team two. Brenda, or any member of team two. Team two, anyone from team two?
Hello, Daktari. Yes, sir. Niko training daktari. Hapa hii training.
Okay, we've muted him. Any member of team two? I can see Jay, Evangeline, Faith, Elizabeth. I can see you, a number of us here. Can you give us your update? Elizabeth, have you met?
Hello.
Yes, we can hear you.
Good evening.
Good evening.
Am I audible? Sorry.
Yes, we can hear you.
Is it Elizabeth Musembi?
Yes, that's Elizabeth Musembi.
Okay. We've officially formed a WhatsApp group.
Yes.
Everybody, I think most of us have introduced ourselves. And we've not officially met as a team, but at least we know whose number belongs to who.
Okay.
Yes. I don't think we have much to add on that.
I would wish to request that team to meet and make sure that you have gone through the question, because we need to have the question ready. And I see it's a team full of lawyers, so the expectations are very high in terms of the kind of input. So the team two will be following up to make sure that by Thursday you give us a better update in terms of your meeting. Kindly request your team coordinator Brenda from Office of the Attorney General to convene. So let's get to team 3. Team 3, any update? Team 3?
Nathan, we have formed our group. I can see our chairperson, Esther Manyaki, can be able to give a brief. Esther, please.
Yes. Esther, we cannot
Can you
hear
hear
you.
me?
Now we can hear you. Go right ahead.
Okay, so good evening. So for team 3, we've been able to meet. We've actually met twice so far. We met on was it on Monday? And we came up with a group name. We are calling ourselves the Data Guardians. And then I'm the leader, assisted by Hezron. And then the secretary is Njeri, assisted by Paris. And we already started working on our assignment. We are meeting on on Thursday to complete working on it.
Okay, thank you. Thank you so much. At least that's a pace setter team, because you realize that they've gone right ahead. We only have a few days. So therefore the teams need to move very fast and convene and move ahead. Let's get to team 4. Team 4. Team 4. Team 4, any member? I see the team leader. I don't see the team leader on board. Any other member of team 4?
I do Nathan.
Yes, Daktari. Yes, you're a member of team 4.
I'm a member of the Big Four.
Yes.
Yeah, we've not met, but we've located the WhatsApp group, but I think we've not met. I think we'll make a move to have a meeting before the end of this week.
Okay. Okay. Thank you. Thank you. We'll be following up on team 4 too, to make sure that by Friday webinar we have really achieved much. Let's get to team 5.
Okay, good afternoon, team. This is team 5. So for team 5, we already have a name. We are calling ourselves the 5th mile, and we identified a leadership team with me as the coordinator. And then we have a timekeeper who is Kanye, and the work of the timekeeper will be to just take the team to complete the assignments on time and all, and remind us of important deadlines. And then we have a secretary who is Wamboi Ruheni. Regarding how to go about the assignments, we've decided to have a meeting tomorrow from noon to 12:30 to just see how we're going to be able to tackle the 3 case studies that were assigned to us. But tentatively, we have decided to now subdivide ourselves into 3 other groups so that each group tackles 1 question, then we can discuss and present at the end. Thank you.
Thank you so much, Elizabeth. Remind me that the name of your group is the
5th mile.
Oh, okay. The 5th mile. Thank you so much. We will be following up. As we said, this training has 3 components. The first component is a safari that we are working together up to 100%. The second component is the webinars that we have just had one, and the third one is the team assignments, which will meet and organize in your teams and make presentations. So thank you so much. I don't have much to say. I would want to, if you could, okay, thank you. I would want to request us to continue with the safari. You notice that now our milestone will now change to milestone 3. That is what we'll be looking at. We'll be looking forward as from Friday. So we have moved. Now we are now looking at milestone 3, which is 53% by Friday. And you notice that many of those questions, most of the people who are asking those questions and engaging are the ones who had actually gone through the units, because they have already. So I want to encourage us, for you to benefit much from this, go through the content as you come for the webinar. Come to the webinar for clarification and for engagement. So we'll be following up for those who are still below in the red zone. I think so far I have 6 now. No, we have about 6 in the red zone. Kindly, but now the red zone will now change because the milestone has changed. So we have quite a number, because now we are looking at those who are 29 and below are now in the red zone, and then now we move into 53%. So thank you so much, and I don't know whether there is any comment from Vera, and then after that we will have a closing prayer. A closing prayer from.
No, nothing. I'm good to go. Thank you.
Okay. Thank you. So let's, Felix, can you pray? Felix Kemboy.
Okay, can you hear me?
Yes, we can hear you.
Okay, let's believe and pray. Father God, we want to come before you this evening. Thank you because of the good work you're guiding us through. Thank you, Father, because of this beautiful day of learning on how we can improve the processes in our country. Thank you, Father, because of the team leader and everybody that is leading us in all this. I want to pray this, trusting and believing in Jesus' name. Amen.
Amen. Thank you. Thank you, and have a nice time. Let's have another webinar on Friday at 2:30. In the meantime, safari.